with today's session. This is Christy Campbell with Sama Technologies. Welcome to today's webinar, Aggregate Spend and the Law. Looks like we do have quite a few people still dialing in, so at the moment I will just go through a couple of logistical items. First, this webinar, as you probably know, is part of a two-part series. Today's session is focused on aggregate spend and the law, and the second session, held next Wednesday, a week from today, is focused on aggregate spend and your data. I think most of you are registered for the second session as well, but if you have not yet, you can definitely go to the link that's on the slide here today and go ahead and register for that. Also, we are recording today's session, and we will make the link available via email. We'll also be sending you a copy of the presentation as well, so no need to take frantic notes today. Also, everyone will be placed on mute. You're currently on mute, and you will be held on mute until the end of the slide presentation. We expect that to take about 45 minutes, and then we will be leaving about 15 minutes at the end for open Q&A. At that time, we will take you off the mute mode and allow you to ask questions live. But please note that the only way that attendees can ask a question live is if when you entered the call, you typed in your unique audio PIN. If you did not type in your unique audio PIN when you entered the call, you can hang up and redial in with that PIN, or you can simply just chat a message through the chat functionality. And the way you do that is if you have your toolbar up, the chat function is at the bottom right. You just type in your message and hit send. If you don't see your chat function, just expand your screen, and then you'll see a little red arrow. Click on that arrow, and then your toolbox will pop back up. Okay? So again, chat your questions at any time during the session, and we will address them in the last 15 minutes. Okay, so let's just move on to some basic introductions then. Today's session is hosted by Sama Technologies. Sama, if you have not heard of us, we're a pure play BI and data management solution provider. We also have a dedicated life sciences practice, and we are really proud to work with some of the largest pharmaceutical and life sciences organizations in the world. Our guest speaker today is Kim Life. She's an attorney with Life & Moran, and they are a life sciences legal boutique. So Kim's got a lot of experience in this area. And without further ado, I would like to hand it over to Kim.
Thank you, Christy, and good morning, everyone. As Christy noted, I am a partner with Life & Moran, a life sciences boutique law firm. We also have an affiliated pharmaceutical medical device consulting firm, Life Compliance Solutions. We bifurcate the two so that your legal and compliance discussions are kept confidential under an attorney relationship. Although we do address general compliance issues, we've been working on aggregate spend since before it was a gleam in Senator Grassley's eye, which is why we're here to talk to you today. Number one, about what you can expect from aggregate spend, and also a little bit about that gleam in Senator Grassley's eye. So why are we here today aside from Senator Grassley? Well, as you know, we have increased scrutiny from all sides, and this includes a number of subpoenas, corporate integrity agreements, as well as the state disclosure issues. Currently, we have 6 states requiring disclosure. More recently, medical device companies have been added, and we've been working with pharmaceutical companies on this for quite a while. And, well, we're happy to see the device companies as companies, but we're sorry you've been invited to the party at the same time. In addition, we have 5 states with spend prohibitions and limits. We also have Connecticut now with new compliance code requirements that's similar to that of Massachusetts. Detailer licensing required in Washington, D.C. And David Catania, who sponsored that bill in Washington, has been very active throughout the United States, and there are some rumblings about getting that expanded to other states as well. We find institutional demands too. So some of you may have encountered a few institutions, including Cleveland Clinic, that are requiring you to disclose what you're spending on their healthcare providers before they'll let your reps into detail. In addition, we've got healthcare providers who are also demanding more accurate reports of their spending. There were a few, actually, a couple of embarrassing episodes for healthcare professionals who were subpoenaed by Senator Grassley, who submitted what they thought was their total spend or total income from pharmaceuticals, and then when Senator Grassley issued a similar subpoena to other pharmaceuticals, discovered that there was a slight discrepancy between those amounts. And so the HCPs are starting to demand a little more from the companies that they're working for. We have a few pending state laws, a lot of them on hold, although at the recent CBI Aggregate Spend conference, the representative from Illinois stood up and announced that after speaking to a number of people, he was withdrawing his support for the bill. He received a standing ovation, and then nobody had any more questions for him, and the poor representative from Vermont was rather singled out for that. So even though Illinois is out, he did mention that they are looking to the Colorado requirement of posting sunshine data, and so they're going to wait to see what happens under sunshine and then look to implement something similar to the Colorado bill. So throughout all this time of disclosing to the various states, a lot of us have been hoping for sort of a unified law that would make disclosure a bit more manageable rather than spread out disparately throughout the states. And so we got sunshine. So I have a slide here showing state disclosure at a glance. This will be provided to you with a lot more detail in the white paper that you'll receive next week, but wanted to give you at least a brief overview of what's required here. As you see, we've got device companies reporting Massachusetts and Vermont, and obviously under sunshine as well as some of the reportable payments and expenses. But as I said, we were going to, you'll see this in more detail in the white paper. But what we do want to do is talk about some of the sunshine provisions. So you need to understand that we don't have a final rulemaking on this yet. What we have is the law, which provides specific guidance to the Department of Health and Human Services, which will be administering the disclosure. But at the moment, we do have that guidance from Congress, and we will be going over this here at the moment to see what exactly we have on the table at the moment. First, there's some important dates you should keep in mind. Next October 1st, we hope to have the final rulemaking from the Secretary of HHS. I say hope because that isn't always the case, but that is the deadline that's been set for the moment. What's important for you right now is that your company will probably need your input into whether and how to address your concerns during the notice and comment phase of the rulemaking. So it's very important for you to get your ducks in a row now. Let your senior executives know some of the things that they might want to raise during the comment period so that the Secretary has as much input from industry as possible. Many of you who have been to the Aggregate Spend conferences throughout the years note that some of these representatives do come to our meetings and they do listen. They understand that we are grasping at trying to find solutions to some of the more complicated reporting requirements, and we're confident that the Secretary will also be amenable to some of our concerns and input. January 1st, 2012, the preemption clause takes effect. And we're going to discuss preemption in a little bit, but you should know that this is a limited preemption clause. Also, January 1st, 2012, you need to be prepared to start collecting your data because the first disclosure is due March 31st, 2013, and that will cover information and data for the calendar year of 2012. And following that first disclosure, on March 31st, HHS will release its release its first report to the public and to the states by September 30th, 2013. So that's when the information becomes public, and there are some policies and procedures you might want to have in place by that time to address any issues that start coming in from the public. So as I mentioned, Sunshine Act also includes medical device companies under their reporting requirements. It covers drug, device, biological, and medical supply companies. And your reportable recipients at first glance looks pretty simple, physicians and teaching hospitals. But any of you who have had a chance to take a look at your customer master database in anticipation of incorporating that information into your aggregate spend solutions might be looking at this and saying, okay, define teaching hospital, and how do we pull that out of our database? How do we identify that? This may be something that comes out of the rulemaking. We may get some more clarification around there, but it is something that you want to start thinking about, and also let your executives know that that's something that we will definitely need more guidance on. So if you're already reporting spend, some of the disclosure requirements don't look too bad, but you do need to watch out for a few. So for example, compensation for services other than consulting, and other to be determined by the Secretary of HHS. That gives us a lot of wiggle room on what exactly